Welcome, everyone, to this Professional Development Hour presentation brought to you proudly by the Atlanta Metro chapter of the Georgia Society of Professional Engineers, an affiliate of the National Society of Professional Engineers. Before we begin, we'd like to let you know that any opinions presented tonight are solely the opinions of the presenter and not that of the Georgia Society of Professional Engineers, the National Society of Professional Engineers, or any other of its affiliates. We certainly hope you will enjoy tonight's presentation, so sit back and relax, and on with the show.
All right, folks, we're going to get going. Our presentation today is Investigations Without the Missteps, Pitfalls, and Consequences. Our speaker today is Mr. Larry Stine. He's a senior principal in the Atlanta labor and employment law firm of Wimberly, Lawson, Steckel, Schneider Stine, PC. He's a former regional counsel for OSHA. He specializes in OSHA, employment discrimination, and wage and hour matters. He provides information and guidance to avoid controversies. Mr. Stine tried his first OSHA case in 1975. And has been representing numerous employers, including handling the largest citation ever issued by OSHA with over 4,800 citations items. He also successfully sued the federal government in overruling the OSHA regulation on COVID in the Supreme Court and successfully striking down the federal government's mandatory requirement of all employees of federal contractors to receive the COVID vaccine. Please join me in welcoming Larry.
Well, thank you very much. And yeah, I did try my first OSHA case in 1975, my second one in 1975, and my third one in 1975, October, November, December. That's the federal government for you as attorneys. So I'm going to talk to you today about investigations. Now, from my point of view, when I do investigations, I can do them for harassment, like sexual harassments. Now, doing sexual harassments is a very interesting investigation, but that doesn't involve you guys. That's a employment issue, but I do discrimination, wage and hour, but I also do OSHA and major accidents. And a lot of times I'm working in conjunction with engineers in the investigation. So I thought I would use an example of an investigation that I did that probably is one of the most complex, complicated investigations that I have ever done in my career. It's the nitrogen leak at FFG, in which 6 people were killed in Gainesville from a liquid nitrogen leak, and a whole bunch of more people were hurt. So just so you know, what happened is I get a phone call from the client saying, hey, we've got a fatality. Can you be here tomorrow? And with OSHA, that's what you do. You have to react very quickly, because fatalities, next business day, OSHA is on the ground. So I go up to meet the client, and they said, oh, we got a conference room full of people. Oh, by the way, this is during the pandemic, pre-vaccination. So I walk into the room, and there are 34 people. There are 6 OSHA investigators. There are 8 engineers from the U.S. Chemical Safety Board. There's the state fire marshal, the fire department brought 3 people in, the cops had somebody there, and I'm walking in the room and it's like, oh my goodness, I've never seen an investigation like this before in my life. Luckily there were 2 attorneys, and what we ended up doing is coordinating and leading the investigation by attorneys and a team of engineers to try to figure out what happened. Why were they dead? Well, I know why they were dead. They were asphyxiated because 2 massive tanks, those big, huge tanks you see on the outside of the buildings? They unloaded both tanks into one room in 30 minutes. They pumped in 12,000 gallons of liquid nitrogen into one room with over 6 people in and other people. And as near as I could tell, those who fell down flat on their back died, and those who landed in an upright position, they were able to pull out in time because the oxygen content liquid nitrogen's heavier than air. The lower down you got, the less oxygen you got. And so they asphyxiated, fire department came in. I had a picture of it. There was one body, it was at 11 degrees Fahrenheit. So now we got an investigation. What are we going to do? How are we going to handle it? What do you do with an investigation? What are the rules for investigations? So that's what I want to talk about. And I'm going to try to pull this case in as we go back and forth. And if you got any questions, feel free to ask them whenever you want, because I'm really good at a Q&A, and that's what this is designed to be. That's the reason I don't have a PowerPoint, is to encourage questions and answers.
Just use the microphone so that you can hear.
Okay, yeah, if you got a question, put on the mic. Oh, this small room, I can probably hear you. So, what is the most basic, absolute rule for an investigator? What is the number one rule that you can think about when you walk into a place to make an investigation? No assumptions. Don't make any goddamn assumptions about what you're looking at, because you don't know. You got guesses, but you can't investigate based on guesses or assumptions. Now, I'll tell you that I had an example of this when I want to explain why it's a mistake, because one of the things I wanted to tell you is misfires. We had an Occupational Safety and Health Administration regional administrator go around and tell groups like you and every group she could talk to, she told everybody, if there's a fatality, there will be a citation. So what happened to her investigators is they were coming into a fatality, and their job was to find a violation, not to find the facts, not to figure out what it is. They came in with an assumption that they were going to issue a citation for every fatality. Huh? So here's the problem. I had these guys do it. I was able to get them in the wrong direction, point them in a way where they could get their citation item and leave. And they did such poor investigations that I had 14 in a row that I was able to beat. 14 fatality investigations, because the compliance officers were coming in with an assumption that there was going to be a citation violation. So they would go around trying to find it, and once they found it, they quit looking. An example was, I had one time when a guy came in, he went to look for an investigation in which an aluminum foundry, this maintenance guy decided to lift up a fence guard, put it to the side, walk in to look at something. After being told he would shut down in 5 minutes, and bend down right as the machine went. And his head was in a press, and his head exploded and it killed him. Well, the OSHA compliance officer walked right there, saw that we lifted the gate, thought he had a violation, and walked away. Had he walked another 25 feet, he would have found an opening in the gate of 8 feet wide. You could have just friggin' walked in. You didn't have to lift the gate, and so it was unguarded. But he never saw it because he stopped when he saw it was lifted and thought he had a violation, and he issued a violation for not having the guard securely fixed. Well, problem is that he was wrong on that being a requirement. He misread the standards. I was able to move for summary judgment and win the case, when all he had to do was walk another 20 feet, and he would have seen an 8-foot opening. But hey, I wasn't going to show him that, and I wasn't going to do it. But the problem is, if you walk in and you start with assumptions, you're going to contaminate your investigation. So the biggest mistake investigators will make a lot of times is they start off with an investigation with an assumption. You can think of police guys going into murder investigations in which they apparently pick somebody that they think's the person and investigate it that way. And they're not always right. So making an assumption is the biggest mistake anybody can make in an inspection. Okay, the next thing you got to do is you got to figure out who to interview, right? All right, now I've got a number of people I can figure out I'm going to interview. How do you do your interviews? Now, you're as an engineer, if you do investigations, you're going to have to do you're going to have to do some interviews from time to time if you're an investigative engineer. So my first rule is no leading questions to start with. Why do you not want to have leading questions? Because you're trying to put some thought into their mouth. And you'll be surprised, there's culture bias in some cultures to always agree with people in authority. And in case you haven't ever run into Hispanics coming up from Mexico, you can tell them, well, the sun does rise in the west, right? And they'll go, you see, yes. Because you're the authority and you told them something and they've been trained not to disagree. So if you do leading questions with people like that, you're going to get the answer you don't want and not necessarily the truth, but if you're leading them that way, they're going to say yes. Once again, you're coming in with an assumption that this is the right answer, and now you're doing leading. So you got to ask open-ended questions to start with. And I'll tell you why I say with a start with in a few minutes. But you cannot lead them. If you're doing it, you're going to contaminate your own investigation. You're going to end up not finding out the facts of the case. So the other thing is, and the OSHA compliance officers are notorious for this, why do you think that happened? You know, I really don't care why an hourly employee thinks this accident happened. I really don't care, and the lawyers don't care, and there's a rule of evidence that you can't lay opinions as to this. So it's completely a useless piece of information, and you'll get every answer under the sun. I've had union guys speculate with accidents defy the laws of gravity. I literally had one of them one time testify that this guy got killed because this machine reached in, grabbed his gloves, whipped them across the thing, and then snapped them up and then rotated. And you're kind of going, which law of physics don't you violate with this one? You know, gravity, centrifugal force. But anyway, that was their story, and that was because they asked speculation. Determine what the personal knowledge is of the individual, right? What do you actually know? If you don't have personal knowledge, why do I care and why do you care as an investigator? Because if they don't have it, what they're giving you is opinions. My thought, and I don't know, but most hourly employees understanding of issues like that aren't really good. And honestly, a lot of the managers aren't that good either. So, you know, they don't really understand what they're looking at or why. Stick to personal knowledge. So you got to figure out where they are. You got to place them, right? Where were you at the time of the accident? I was next door having a coffee. Well, I don't really want to ask this guy much of anything unless I want to know what coffee he had, because he's really not going to give me anything, right? So you got to establish personal knowledge. And if you get into court and you try to get somebody to testify about something that's not personal knowledge, watch the other lawyer get up and object. And watch the judge sustain the objection, because you're asking questions about personal knowledge. And it's going to lead you to the wrong place again, because they're making assumptions and you don't need to do that. So, any of y'all ever done a bunch of interviews? Okay, good. How many people tell you the truth?
Maybe half.
Maybe half. Okay, you're more cynical than I am. I'm of the belief that 10% just lie through their teeth. They just flat out lie. The rest of them, they don't understand what they're doing, they misunderstand, but they're not trying to lie to me deliberately. But 10% of everybody I interview or gets on the stand, I know there's perjury, 10% lie. And they know they're lying, and they're deliberately lying. And so you got to test veracity, right? How do you test veracity of a person you're interviewing? How do you go about testing the veracity of somebody you're interviewing? Anybody have any suggestions?
Know the answer to the question before you ask it?
Well, yeah, except for I'm trying to figure out the facts without doing it, but yeah. Sometimes you're still in the fact-finding stage and you don't know yet. In this FFG, we were 5 months into the investigation until we finally figured out the cause of the accident. Never did figure out the why it occurred, but we know why it occurred. And I'll tell you a little bit later on why it occurred and how we got there. But one of the things that lawyers do, and I do it too, is I will ask a series of questions in the first 5 minutes over here. Then I'll ask a bunch of more questions here, And then 15, 20, 30 minutes later, I'll go back to those questions, but I'll ask them in a different way. And if those answers are different over here and different over here, I got a veracity problem. Something ain't right. They don't understand the questions. They haven't understand what they're saying. Something's wrong with their veracity, and you've got to do it. So you got to go to the early questions and then the late questions. And you'll be surprised how often people will change their questions. And the other one is some witnesses give the correct answer as opposed to the truth. Now, what do I mean by giving the correct answer to instead of the truth? Anybody, you know what I mean by that? Well, they're trying to figure out what is the way that they come out the best. And what is the right answer for them to appear the best they can be, okay? I call it the correct answer instead of the truthful answer. And the worst witnesses I've ever had in deposition are those witnesses. And let me tell you, almost every lawyer can figure this out. This is not something that is hard to figure out. You begin to see what's going on. Do you know what lawyers do to people and witnesses who are giving us the correct answer? Anybody have any idea what a lawyer would do or your investigator would do when somebody's giving them what they think is the correct? Well, I'll give you an example from a trial I had. In this particular case, I was a federal attorney for the OSHA at the time, and this employer testified that the piece of the citation that said he had 15 days to contest was blank, and he was late, by the way, so if this was critical to his case, because if it wasn't blank, he was going to lose his case. And so he was lying through his teeth, because it was a two-sided form, and I know he got it. But he was lying to me, and he was trying to make it so he could present his case. Well, I then took a moment and I went to him at the stand and I went, and it's a fact, sir, that you didn't even call your attorney when you got that citation, did you? Yes, I did. His attorney jumps up and says, let the record be that I was not that attorney. He lied through his teeth and he lost the case right there. Because the judge ruled that when he talked to an attorney, he should have known he had 15 working days to contest, and therefore he lost the citation. But he was lying through his teeth. He never talked to that attorney. But I implied the correct answer was yes, he did, and because he was trying to figure the correct answer instead of the truthful answer, he lost the case. And you will get witnesses like that. The way to do it, and remember I said don't ever do leading questions, and notice my comments was at the start. That doesn't mean I cannot use leading questions later on. And in this one, what happens is you then take that question and start writing and asking it in such a way that it implies one answer and you know the other answer is the truthful answer, and they will lie to you. And now I've got veracity. I'm not paying any attention to this particular witness, okay? So the investigator's got to do that particular aspect. I like signed statements, okay? I like the witnesses to sign them. They won't always sign them. But when you can, get them signed as a statement, and do it as early as possible. Because people have vested rights and try to change their story sometimes, having them signed is very interesting. I'll give you an example. I was trying a sexual harassment case downtown with this very pretty young black woman, which worries me a lot when they're pretty and young, and my alleged harasser is an old cranky black guy. By the way, I got very lucky he left the state so they couldn't call him. So I did have a piece of luck. The problem for her case was this company had the policy that when you made a complaint, you had to put it in writing and sign it. So she tells one story in that statement. She then goes to EEOC, tells a slightly worse story. I take her deposition, the story gets a little worse then the story gave to the company and then to EEOC. I then moved for summary judgment because what she had told me was not enough to win the case. She then files a written affidavit making the case even worse. And at trial, she tells a worse story than that. So basically what happened is I was able to cross-examine her on her first signed statement compared to what she testified at trial. I then used the statement from the EEOC to impeach her, and then I used her deposition to impeach her because every story got worse. And the problem was at trial, how many stories did she tell? 5. And my statement to the jury was, which story are you going to believe? Which one of the 5 stories are you going to believe? By the way, they brought another witness who even gave a worse statement. This guy came on and claimed my sales manager was showing porn at the sales meeting. It's kind of like, you know, some other witness should have noticed that they were showing porn during a sales meeting. But that's literally how bad it got. So the exaggeration helps, but sign statements as early as possible. Not everybody will sign them, and you can't make them sign. Now, you can depose them, which is under oath, and that's the same, but that doesn't come early. That comes much, much later in the investigation. So those are the things about the interviews. You got to identify those people who are involved in the investigation, get their personal knowledge, figure where they are, and then interview everybody you can. Okay, so that's the interviewing process. Anybody got any questions about that before I move on? Okay. All right. Documents. Paper, right? Now, this is where the engineers start coming in for me because I can do the interviews. I might have an engineer with me to help me if I'm interviewing another engineer so he's not bullshitting me, but hey, I've done that repeatedly. I had 2 attorneys in my office that are also degreed engineers, and so typically one or the other would be with me when I'm interviewing engineers. And by the way, some engineers will lie through their teeth just like everybody else. The worst cross-examination I ever had was an expert who just lied through his teeth. And you remember about the correct answers? I took his deposition, he gave me 20 correct answers. Twice. Because I asked him in different ways. Remember how I told you ask questions in different ways? Let me give you an example of that type of questioning and the way it works. So we were fighting over tying off the lanyards on the top of a building that they were building with the cast in place concrete, where they're actually literally on the very top floor the whole time, right? And at the time, the OSHA rule says you had to tie off above your head. The manufacturers for the lanyards have since changed the recommendations, but the reason, it makes good sense from a good point of view that they have the stress go down like that instead of this way. So OSHA was taking the position, this expert was taking the position that you had these wire ropes around the perimeter of the building, right? And that you had multiple people and they would tie off. So we were asking questions, and by the way, 2-day deposition, just so you know. So the first day we're talking about the lever principle on the point in which it was secured to the wall, or to the ground, right? And the stiffer the cable gets when they fall, the greater the lever applies to that point and greatly exceeds the power that the anchorage can handle. So we're asking him that particular question. He says, oh, that's easy to handle. You just make the cables nice and loose. And we go, and so therefore when it falls, you got elasticity and there's no lever principle, and so it doesn't have to be that strong. The next day, we're talking to him about having 2 or more people tied off on it, in which if it's loose, it's like a guy during bow and arrow. The first guy goes off, and the guy that's on it kind of gets taken and flung off the building that way because he's just been shot off by the snap of the loose cord. So how did he answer that one where I basically told him if it's too loose, he'll take him off the other guy off the building? He says, oh no, you just make it as stiff as possible so there's no thing on that. He did it 20 times, by the way, in his deposition. So, you know, that's what a correct answer will get you as opposed to the truth, but that's what he did. By the way, we went to trial And when I got to trial, I had 20 questions of where he'd done A and B 20 times. And so I took him up there, and the first 20 questions were, tell me about this. And if he gave an A, I pulled out the deposition and made him read B. If he gave me B, I made him read A. So after 20, but that son of a gun, I'm asking him question number 21, and he lies to me again. So you know what I did? I reached back and grabbed the deposition book like I had number 21. He changes his story. He did. He changed the story to the answer I wanted because he had lied to me again, but he was terrified of me whipping that book out and making him read the 21st time. So that's one of the things about the correct answers. Now, the documents, we'll talk about the FFG thing. Now, what happened in the, that is they had just installed a liquid nitrogen bath and a liquid nitrogen spiral freezer. The idea behind it was they were doing cooking chicken parts, okay? Nuggets, for example, chicken strips. And they would bread them and they would put them through the liquid nitrogen bath because it would flash freeze the coating so that when they put it through the spiral freezer, they wouldn't lose any of the coating. So they literally ran it through a bath in this, and then they put it into a liquid nitrogen spiral where they sprayed at the top liquid nitrogen in there. So that was what's going on. My client, the employer, had been operating that mechanics for 4 weeks. It was still in a test. The manufacturer was still there giving us feedback on what was going on. And something went wrong badly, and the 2 big tanks outside emptied into the liquid nitrogen and overflowed the room with 12,000 pounds of liquid nitrogen, which then asphyxiated everybody because it displaced the oxygen. So first thing I did for documentation was I got the pictures from the fire department. That's how I can tell you that one of the bodies was 11 degrees, because I have a picture of the firefighters putting one of the gauges on it, and this goes 11 degrees Fahrenheit. So that's why I knew that was. And so we had pictures, we could see the ice. So that's one of the documents that I got. The other one was, hey, it's a big to-do between who the company that was building it and providing the liquid nitrogen, who, by the way, is like the 800-pound gorilla in the industry. My client had like 200 people in the entire plant. And my guys, and the information going back and forth, the emails and the text. Now, when I first started working as an attorney, I didn't have to worry about emails or text. There was no such thing. As a matter of fact, when I first started working in 1975, I walked into an office that operated the same way as in 1925. Literally. We had telephones, typewriters, carbon paper, onion skin paper, the United States mails, and books. The next year, we got a copier. Just so you understand technology. We didn't even have a copier my first year. Same thing as 1925. Nowadays, I've got so much technology, you've got to be able to handle that. So you've got to be looking at the emails, right? You got to pull all the relevant emails, and you got to go to IT and give them search terms, because they're not going to search, you know, the millions of emails that get sent all the time. You got to have a search perimeter. You got to come up with words, right? You got to figure out what words am I going to use. And nowadays, the text, in some ways, particularly in these construction projects and these building projects, I swear there's more communication going on with the cell phones texting than there is the emails. So now you got to gather up everybody's phone, start doing a forensic examination of the phones, and it gets a little complicated because a lot of what's on phones is not be seen by investigators or the other side, because there's a lot of personal stuff, and then you have to sort that out also. So you've got to be looking at the emails, you've got to be looking, by the way, there's still writings, there's still papers being sent. You know, typically they're going to send your blueprints, your drawings, the signs, that sort of thing for you to look at. So you got to make certain you've got the emails, the text, the written communications. And you got to look in the oddest places. When we had to open up the cabinet, and it was a 600 volts or 660? My brain just went blank on it, but anyway, it was high voltage. So we went in with somebody using the arc protection to open it up. And guess what happened when we opened it up? There was paper inside, there was drawings inside the electrical cabinet. I don't know who they expected, I just don't know how they expected my client to find those papers, because they put it in a place they're not supposed to open, but that's where they were, and so we found some that way. So you got to look at some odd places to find your paperwork. Now, one of the other documents that's out there now are videos, right? Cameras. When I first started doing fatality investigations, and I have done, I think, over 1,000. I've lost count a long time ago, but that's what I do a lot with OSHA, is this. We use photographs. I now have seen probably a dozen snuff videos. So I get to watch people die on videos. I know, it's a little bit part. I have a black sense of humor, by the way, as you can imagine. But because the cameras are so prevalent in industrial settings and in trucks and all over the place, there's normally video that you can see. And there was video in this one, so we could see what was going on. I don't know how helpful it was in investigation, because we knew where the bodies landed, we knew their boots were frozen to the ground, and when the firemen took them out, they literally lifted the bodies out of the boots. So when I went into when they finally released it and I could go in there, and I spent about a month and a half inside this freezer, by the way, handling interviews, investigations, etc. It was there. So now, also photographs, right? What the first thing we did, what was the first thing the engineers did when they went in there? I'm talking about the chemical safety guys, the OSHA people, and then my people were coming along doing the same thing. Oh, they took pictures all over the place. And my people, my instruction to my people was, if they take a picture from one angle, I want you to take it from north, south, east, and west. Now, why do you think I want a picture from the north, the south, the east, and the west? Huh? Context. Yeah, because their government will take pictures out of context and in only one angle where it looks the worst. Yeah, they will. That's a technique they use all the time. Oh, that's really bad. Let me get a really good close-up on it, and then the aperture looks like it's this big, and I got a picture from over here, and the aperture looks that big, right? So you got to take pictures east, west, north, and south. And whatever the investigators take a picture of, you need to take 4. So I had one guy whose whole job on my team was to take pictures. That's all this guy did. And remember, I had 6 OSHA compliance officers and 8 engineers from the U.S. Chemical Safety and Health Board taking pictures. And just trying to manage them in and out of the plant was, I had a couple of battles, by the way, with the General Counsel for the U.S. Chemical Safety and Health Board and with the Regional Counsel for OSHA, my successor, about what they could do and what they couldn't do. Because we have a constitutional right to limit them, and that's what we did until they finally went and got a warrant on me. But until then, I could control it a lot better. So you're taking pictures. Now, this is going to sound odd because I've had it happen too many times. Measurements. Now, I know every engineer who's worth his salt understands the first thing he's going to do is take measurements, right? I'm going to measure every goddamn thing I can. I'm going to take that tape measure or that laser measurement, and I'm going to measure it up, down, sideways, backwards, till I know every angle, every way to do it. Folks, you'd be surprised how often OSHA compliance officers forget to measure. And you ought to see how much fun I have when we go to trial and they haven't measured anything. Well, what's that distance? Oh, it's about 3 or 4 feet. Did you measure? No, so you're guessing, aren't you? Well, yeah, it's an educated guess. You don't know, though. You didn't measure, did you? No. That's a dumb dumb investigative technique, but I can tell you, they do it all the time. Well, in this one, because it was, by the way, the insurance coverage was $300 million. I did not handle those cases directly, but I'm pretty certain the insurance company paid out $300 million. I'm about as certain as I can be on that one without having actual facts. I did work together with the plaintiff's attorney because his interest and my interest actually coincided, which is weird. But I was battling the big 800-pound gorilla in the industry. He was suing them, and I'm trying to blame them. So our interests are the same in the investigation. But so
the 800-pound gorilla.
Messer.
I was going to ask, machine industry or gas industry?
It's the gas industry. Messer had, by the time this happened, Messer had bought the 2 big companies in the United States and is headquartered in Germany. And it's hard to get compressed gas without going through Messer. And so Messer is a multi-billion-dollar company, and my company was, like I said, had about 200 employees. A decent-sized factory, but it's like, David and Goliath, honestly, with the resources that they brought in. And they brought in a team of lawyers all the way from LA with LA rates. I'm not quite certain why, but that's what they did. But so basically, in the investigation, it's me and the plaintiff's attorneys, weirdly enough, against Messer and their attorneys and their team. So they had investigative teams. OSHA had their team in there. The U.S. Chemical Safety Board had that, and I had every one of us hired a consulting engineering. So we had different competing engineering companies, going and coming out with the information.
So many of us have to avoid conflicts like that. That's why there's so many forensic firms.
Yeah, because there was definitely conflicts between them. Now, let me tell you, I'm going to tell you what the result is of the investigation. And what happened is, and I'll go into this in a minute, but I just thought I'd tell you what the result is. It turns out that this machine, the liquid nitrogen bath, had one sensor. It was a bubble tube. And basically what happens is it would read, as the liquid nitrogen came into the bubble tube, it would rise into the tube and it would send a signal back to the computer, hey, we're full, stop. And on the engineering drawings, it had 2 bands, one here and one here. Well, when we took the pictures of this, and by the way, they did micro photographs, structural analysis, x-rays, just everything every forensic engineer wants to use, they used it in this investigation. We used some stuff. I'm having to go to the engineers and going, tell me what we're doing again? Because I don't quite understand what you're doing here. So would you explain it to me in English and quit the engineering vernacular and talk to me in English, and I'll translate the legal stuff back to you in English. Somehow, and the bottom one didn't get in, so it was loose. It got bent. And it got bent up, so here's where the liquid nitrogen level would come before it overflowed. And the tube was bent like that. So it was just slightly above the pool where it overflowed. And so what was happening is the signal to the computer that we're full never came. And that's the reason they dumped 2 liquid nitrogens in there, is because it bent. Now, the next thing you want to try to figure out is how in the world did that get bent? Right? Okay, I don't know. The other side doesn't know. The engineering firms don't know. We speculated. I can tell you, we speculated as to how it got bent that way, and everybody had a different theory based upon their which way was best for them. Which, hey, I am a lawyer. Somewhere along the line, I quit investigating and I go to advocating, okay, with the facts. We never did figure out how it got bent over and why it didn't start overflowing for 2 hours, because it ran for 2 hours before it started overflowing. So I always thought that something occurred in that time frame from 8 o'clock till 10 o'clock when the accident occurred, because it was working up in that point. And I always was kind of the iceberg glacier thing that came in and hit it and bent it up with a block of ice coming through because it was so cold. I always thought that was the most logical. The other side argued that our sanitation people the night before were pulling hoses and bent it up. The problem I always had with that theory was, well, why didn't it overflow when they turned it on at 8 o'clock in the morning? Why did it wait till 10 o'clock in the morning? I know when it overflowed. I've got the charts, because remember we talked about the paper. Here's the flow coming in, here's the flow to right here at this point, and all of a sudden it goes up like that. It empties the tank 30 minutes later, and it goes down to there. I know exactly when it happened because of the charts. I know where it went, where it got to maximum, and when it dropped off because it emptied the 2 tanks. So I know why it was, but part of the problem sometimes when you do an investigation, and I think part of the point I want to make is, you don't always get the final answer as to why it happened despite what you do. And that's one of the problems that we've had with OSHA and me and the U.S. Chemical Board and the other attorney we're dealing with it. They wrote a first report and we went back to them and said, guys, you forgot to look at this, you forgot to look at this, you forgot to look at this, and this is what it is, and you're too much on Messer's side. And they rewrote the report. And they made it a far more balanced report. Now mind you, why would I care about a report from the U.S. Chemical Safety Board where there's no penalties? Because they're the neutral ones, and if they had said it was my fault, I guarantee you OSHA would have used that to prove their case. By the way, this case is not over because Justice has been investigating for criminal charges now for 4 years. By the way, one of the dumbest theories I've ever heard. They're investigating a general duty violation of the Clean Air Act, which makes it a crime to put toxins and pollutants in the air. And I'm talking to the justice attorneys and going, guys, look at the periodic table. Look at nitrogen, and nitrogen's an inert gas, guys. And it's 78% of the atmosphere. So how is it a pollutant? I'm breathing 78% of this stuff right now. By the time I got up and think, it was 78% when it went into the air. I think that's one reason they've been taking 4 years to try to figure out what to do with it, because they're so dumb. And now this is, I'm going to denigrate my profession for a few minutes, okay? I know y'all do it all the time with a regular, propensity, and I understand. I got too many lawyer jokes. Oh, if you want one, I'll give you one. I'll give you. I'm the repository of great lawyer jokes. I'll tell you one in a minute. But the problem is most lawyers tend to be English majors or social study majors, huh?
My dad was a lawyer. I
Okay.
understand.
You understand? Okay. Yeah. And you put math in front of them, and it's like you just put a foreign language in front of them. Well, I'm a little different. I was a math major for my sophomore year and took calculus and statistics and all of that. So I actually like math and can actually do math and spreadsheets. And when you talk to me math, I actually can understand it. But most lawyers, it's like high-flying jets because they're English majors. And the reason they're not doctors, they flunk organic chemistry. And the reason they're not engineers, they never could get math. Okay? Just so you know what there is. Now, the last stage for something like this is testing, right? Now, I will tell you a lot of times when we're doing investigations, the money's just not there for testing. Testing is expensive. Well, in this particular case, since we're talking about $300 million or so, the testing didn't seem to be that high. So they built a full-scale model And they took water, not liquid nitrogen, and they put the bubbler tube in, and they ran in the bubbler tube with the simulation, with the actual mock-up, and it shut down every single time. They went back in and then bent the tube to the angle. And by the way, this tube was such low stainless steel, I could bend it with my hand. They put such low gauge stainless steel on it. They didn't clamp it. They matched low gauge that you could bend it like this. So ultimately,
Design flaw.
Well, that's the reason Messer's Insurance paid out $300 million, because it didn't get built the way it was designed. They didn't put the second clamp in. They used stainless steel that you could bend with your hands, and there was no duplication. There was no redundancy. If that failed, it failed. There was no redundancy system. There weren't two bubbler tubes. There was one. And it was a huge design flaw. And so that aspect, by the way, we may not know why the tube was bent, but we knew it could easily be bent in the condition it was, and once it was bent, there was no redundancy. That's the reason Messer's Insurance Company paid out the maximum coverage to the there was 5 families. One person died with no family, and they don't get much. If you die without a family, no matter how bad it is, in our country, you don't get anything. You don't get workers' comp either, by the way. You get very minimal workers' comp. You got to have somebody to take the money once you're dead. I know that's harsh, but it's the truth. So they did mock-ups. They brought in the micro photography and did the stress and looked at it. They measured the angle it got bent and tried to figure out how they could bend it and what could do it. They tried to duplicate the bending, and that's where they couldn't get it to do. And I think part of the reason they couldn't get it to do is they were using water and not in a liquid nitrogen atmosphere, which I can understand why you don't want to test in a liquid nitrogen environment and have it fail. You know, that's just not what you really want to do. That's an unsuccessful test if you've ever done that. So I'm trying to keep my time right for you guys. Okay, I have gone. It's time for Q&A, isn't it?
If you got one more, that's fine too.
Okay.
Some time ago, I was reading about an arson conviction that got overturned. Sir Conan Doyle wrote Sherlock Holmes, if you have all the possible causes and you eliminate all the plausible ones, it can only be the one that's left. That was the basis for why the guy was convicted of arson, and it got overturned because that. You care to comment for the standard of evidence in that case?
The standard of evidence in a criminal case is beyond a reasonable doubt. And what a criminal defense lawyers are always trying to do is create just enough doubt to get past the reasonable doubt. That's not the burden for civil. The civil burden is a preponderance, which just means if I can't make up my mind, I'm going to rule against the one who has the burden of proof. That's fundamentally what it is for civil. But criminal, if you can plant a doubt in a juror's mind, you can get a acquittal, even if they're guilty.
What I was reading was NFPA standard for arson investigations disallows the Sherlock Holmes basis for convictions.
Okay. Well, but fundamentally, when you're doing an investigation, ultimately, you're talking about, you take all the results, right? We've talked about how to get the results. You finally get the results, you've got to apply the results to the world. You got to figure out what it is and come up with the most plausible theories, the reasons, what happened. Or come up with a fact like I ended up coming up like a danged if I know. Nobody could figure out why I got bent. But we could figure out that it should not have been bent. So for the burden of proof differs, Roger, for what you're trying to do. For Messer, it was a design flaw, right? And so I don't have to tell you necessarily why it happened. All I got to do is show too low, it wasn't properly banded, stainless steel was too flimsy, could be bent with a hand, and you didn't put any redundancy in the system. Those are design flaws. That's what my engineering guys came up with, that was their conclusion, is there were design flaws in the system. My argument to government for my one is, my guys didn't know this. You know, Messer was the one with the expertise. We were just taking over the system. We had no knowledge whatsoever, which is an element that government has to prove in a civil case, knowledge.
In my reading this morning, I came across an acronym I had to look up, FRE. FRE.
FRE, Federal Rules of Evidence. Okay. All right, he wants me to expand on Federal Rules of Evidence. Basically, about 1974, the federal government rewrote the rules of evidence. They used to be common law evidence, and a bunch of professors and academics and practicing lawyers tried to basically codify those rules of evidence, and they prepared the Federal Rules of Evidence. And since 1974, the feds have been following the Federal Rules of Evidence. You'll be glad to know that Georgia in 2022 decided to adopt the Federal Rules of Evidence fundamentally, but hadn't done that until 2022. So they were still using common law rules up until that time. So, you know, so where you would make an objection to hearsay, you'd say, objection, Your Honor, hearsay. Now you can say, objection, Your Honor, Federal Rules of Evidence 803. And I will tell you, I used that one time when I was a very young attorney. I was trying a case, and I was the first class in law school to be taught the Federal Rules of Evidence. It literally was the year before I took federal evidence, and they taught the Federal Rules of Evidence. And I'm trying the case. I'm about 26 at the time, and there's a grizzly old attorney who probably is 20 years younger than I am now. And he was objecting to every question. He was trying to throw me off my game by just objecting to every question. The problem is when I do, even back then, I just write bullet points. I want to make points. I don't write questions because you get lost. But I wouldn't check off the point until I got an answer to the point. So it didn't matter. And so it was his turn to get up, and he's grizzly, and he doesn't know the Federal Rules of Evidence, and I'm in front of a federal judge, and he does a hearsay, and instead of saying hearsay, I stood up and said, Your Honor, I object pursuant to Federal Rules of Evidence 803. And the judge gets a twinkle in his eyes. Swanee, he got a twinkle in his eyes, and he looked at me and gave me a little smile because he knew what the other guy was doing to me. And he went, Mr. Stine, I think that's a well-taken objection. What do you think, counsel? Well, I had the Federal Rules of Evidence in a book, and I'm looking at it. This attorney walks over and grabs the book out of my hand because he had never had this happen before. He doesn't make another objection the rest of the trial. It was like, okay, truce, I won't give you this and you won't give me Federal Rules of Evidence numbers.
How do they differ?
One of them was common law, where basically the judges did it and you had to go look at case law. And the Federal Rules of Evidence, it's written down in very specific terms what the exceptions are. Now, mind you, there's case law that interprets them. But one of them is more kind of case law and what the judges allow and what they've learned over the years as opposed to having it codified. And believe me, it's much easier to have it in a book where you know what the rules are and you can look them up ahead of time and be prepared. So that's the difference, Roger. All right. Y'all did ask for a lawyer joke, so I'm going to give you one of my favorite lawyer jokes, okay? So there's a lawyer, a farmer called out this lawyer, and this lawyer is wearing his best clothes. He's wearing the Gucci, shoes, the nice suit, and he's walking out in the pasture with a farmer in there walking around, and he steps into something brown and gooey and ooey, and he looks down at it with a pained look, and he says, "Don't tell me." The farmer looked at him and went, "Yep, you're melting." My favorite lawyer joke. So, any other questions? I think I have done your hour for your thing. Anybody else? I'm more than glad to answer questions.
All right, well, big round of applause.
Thank you. Oh.
This is a small gift on behalf of the chapter.
Oh, okay, great.
Appreciation for coming up here.
Thanks. Like I said, I love to talk. It's not hard to invite me and for me to accept an invitation to talk because that's what I do, guys.
Thank you.
Okay, sure.
All right, folks, we're going to have the drawing.
We hope you enjoyed this presentation given at one of the Atlanta Metro Chapter meetings of the Georgia Society of Professional Engineers, an affiliate of the National Society of Professional Engineers. To find out more about us or to join us, check us out at gspe.org.